May it please the Court. When all is said and done, when the questions posed by this Court have been asked and answered, we come down to a single final issue, which is this. What the appellants are asking this Court to do, and in fact what the Court must do in order to arrive at the conclusion that they seek, is read a statute that says that returns must be filed by a date and time certain as though it said may be filed, to read a statute that says that the Secretary of State may accept late filed returns as though it says must accept late filed returns, to disregard a statute that says that the Secretary of State's opinion as to election matters is binding upon all those officers and agents within the election system, and to disregard the well-established and long-standing doctrines regarding clearly erroneous standard and implied repeal. And finally,
would you address the question that was posed before, that if we stop, or if you have the 7-day cutoff, do recounts stop at that point, or do recounts continue to be used as part of the contest?
Well, I think the recounts must stop if the 7-day cutoff occurs unless the Secretary of State, in the exercise of the discretion that the Florida legislature has given her, determines that there is rational reason for them to continue. It is the job of the Secretary of State. It has been reposed in her by the legislature, and two constitutions, the United States Constitution and the Florida Constitution, in unusually explicit language, have delegated that decision not to the state of Florida, not to the courts of the state of Florida, but to the legislature of the state of Florida. And the legislature of the state of Florida has reposed that authority in the Secretary of State. Now, in order for us to do anything else, this Court would have to disregard the most fundamental principles of separation of powers and do what these appellants are asking, to step into the shoes of both the legislative and the executive branches, to rewrite these statutes, and to begin the process, which I suggest to this Court is never-ending, of sitting as a determiner, of an ultimate arbiter of the minutiae of